Hello, everyone, and welcome to today's webinar, Contracts 101, brought to you by Whiteford, Taylor, and Preston in Leading Edge, Maryland. Before we get started, I'd like to go over a few items so you know how to participate in today's event. You have joined the presentation listening using your computer speaker system by default. If you prefer to join over the telephone, just select telephone in the audio pane and the dial-in information will be displayed. You will have the opportunity to submit text questions to today's presenters by typing your questions into the questions pane of the control panel. You may send in your questions at any time during the presentation. We will collect these and address them during the Q&A session at the end of today's presentation. Today's webinar is being recorded and you'll receive a follow-up email within 24 to 48 hours with a link to view the recording as well as a PDF of the slide presentation. And now I'd like to introduce Sigrid Haynes and Caitlin Zaro, attorneys at Whiteford, Taylor, and Preston. Welcome.
Hi everyone, this is Caitlin Zaro. We're excited to be with you. Sigrid and I will pass the information sort of back and forth, so you'll hear us both interchangeably, but I'm going to go ahead and get started. So this is Contracts 101. And, one of the most basic items that we'd like to emphasize to everyone is that you need a complete contract. So the contract memorializes the meeting of the minds of the decisions that you're making with your opposing party. But the contract needs to be complete. It should have every element that you are agreeing on, both business terms and legal terms. There should be no blanks that you are still considering. It shouldn't be a rough draft.
People sign red lines. This is Sigrid Haynes. People sign contracts with red lines. They sign them without the blank spaces being filled in. So in order to have a complete contract, a court would look to have a meeting of the minds of the parties. And we say a court because if there's a fundamental disagreement, it ends up in a lawsuit. And there should be a meeting of the minds as to the essential elements of the relationship. And I see a surprising number that are left with blank lines for the amounts to be paid, the services to be performed, some of the key elements of the contract, and it's very important that those be set forth, as that is the purpose of the contract, is in order to establish the relationship.
Absolutely. And we need to make sure in the event that the contract references that there'll be exhibits attached to the contract or schedules of additional information, that all of those items actually get attached to the contract and make it complete. Because if you're referencing things inside the contract that reference other documents or attachments and those aren't there, that's an incomplete statement, and we can't find that information as you intended it at the time that you created the contract. And this seems obvious, but you need to make sure it's actually signed and dated. Many times people are so exhausted by the end of a negotiation that they've assumed that the final I's are dotted and T's are crossed. But in fact, that's one of the most important things that still needs to be done. So again, going to making sure you have your I's dotted and T's crossed, is you need to make sure you save a copy of the contract. Scanning and saving the contract is fairly easy these days. And if you have an attorney that's assisting you in the negotiation and drafting of the contract, it's important that they receive a copy as well, so that they can be an easy reference for you to pull it up in the event that you can't find it.
With staff turnover, it's surprisingly difficult sometimes for people to produce copies of the contracts they have signed. Larger institutions often have contract tracking systems, but a lot of my smaller clients, they might have them in a file drawer, or maybe they can't find them, maybe they cleaned it out, maybe the person has been replaced, the comptroller left last year and the new person's in, and they don't necessarily know where the contract is. So having a copy is better, and having is very important, and having your attorney have a copy can be very helpful, because I do get calls from clients saying, hey, we signed a contract 2 years ago and I might only have drafts or red lines or various versions of it, but if I have a signed copy, then it's very helpful. I can give it to the client as opposed to having their copy. And there are a few things more embarrassing and awkward and potentially problematic than having to call the other side to see if they have a copy of the contract.
Yep. And obviously, once we have a complete contract that's been signed and filed away, we hope that you're happy with it. You know, that you've had a meeting of the minds, that you understand everything that's in the contract, and the contract memorializes how the two parties intend to deal with each other in this specific context that the contract addresses. So, for example, if there's something that you don't understand, or you know that is not how it will work in practice, as a practical matter, then that should be fixed before it's signed and completed by the parties. The contract should both make sense, protect you, and reflect how the deal will be done as a practical matter. In the event that something changes between the parties and the deal terms no longer make sense, you need to amend the contract. Instead of just going off and doing something differently, you should memorialize that in writing and specifically amend the specific section of the contract that's been changed.
How would you feel, Caitlin, if I were to be in a contract with you and we decided to change the terms, and I just sent you an email and I said, hey, I've decided instead of paying you weekly, I'm going to pay you monthly. Is that okay? How would you feel about that as a contract amendment?
It really depends on the relationship between the parties and the significance of the term that's being changed. So if it's the frequency of payment, I think that could be done in an email, especially if there's.
Do you need to reply, or can I just send it to you and hope everything's okay?
You want to have confirmation from both sides that they agree that that's the way that they see it functioning in the future. So I agree, I would want to reply. It's always safest to have an amendment, but sometimes emails will suffice. If you get into a situation where you cannot agree to terms of an amendment, or parties are just ready to go their separate ways, you know, there's a lot of ways that we can deal with that. One is hopefully you can negotiate a termination. There is already a negotiated termination right in the contract. If you're in a situation where the facts and circumstances don't trigger the negotiated termination right that's already in the contract, you can separately negotiate terms to terminate the contract if you both agree. If you're in a situation where the parties are not able to agree on a termination, you can look at what remedies are going to be available in the event that you just breach the contract. Sometimes it's a balancing act as to whether it makes sense to just breach and let the other party go through the remedies that are available to them. You know, it's worth it to you to do that for whatever reason. But other times those remedies are so severe that could deter you from wanting to breach the contract. So there's just a balancing act as to why you need to get out of the contract and the consequences of doing so.
I had a little war story that I think illustrates this well, which is I was representing a physician who had taken a position as the medical director of a large national lab company that we've all heard of. And he was going to be their medical director, and he was going to start in about 9 months. And when he went to his current employer and told them that he was leaving, they begged him and gave him some financial incentives not to leave. So we invoked the termination clause in the contract, and he hadn't even started the position yet, but I think he could terminate on 90 days notice or something like that. And I wrote the letter to the large national company, following very carefully as a lawyer, and I spent an hour going through the contract and following all the termination clause language and, sending the letter to say we're invoking article blah, blah, blah to terminate. And I got a call immediately from the lawyer from the other side. Oh, thank goodness, we were going to send you the same letter because the deal no longer made sense for either side. And so we terminated effective immediately, and everybody walked away and was happy. So it was an example of good communication that enabled us to make everybody happy quickly as opposed to a formal discussion. And we didn't have to wait 90 days for it to be terminated. We wrote each other a letter and said contract terminated.
Mm-hmm. Yeah, absolutely. So you'll find in the negotiating process that you learn a lot from the opposing side, especially if it's your first interaction with them. But I'd say in every situation you learn something about the party that you're negotiating with. You know, each party comes to the table in order to protect themselves from certain risks. You know, a contract is always about risk allocation, but also obviously each person has specific business terms that are important to them and are specific to their company or situation. So we're always balancing in the negotiating process the relationship that you're trying to create and maintain going forward, while also protecting your interests in a way that, you know, makes sense for you.
And I always say you can't hold a bad party to a good contract because it is a very important process as part of the negotiation. I had we actually made a job offer to an associate some years ago at my prior firm, and she came back with so many nitpicky contract offer revisions that I was instrumental in having the contract offer, we withdrew it because it was so petty in so many ways that I thought, I don't want to work with this person who's going to torture me about whether her health insurance deductible is $100 or $150, because it's going to change anyway over the course of the relationship. You know, we hope to work together for 30 years, and I can't work with somebody who's going to be that, in my view, petty. You know, it's one thing if it's a very brief, if I'm calling a painter in and I'm going to have the painter paint my house, the painter, okay, fine, you know, he can give me, I want another $150 because you're insisting on premium paint. It's a short-term relationship. It's a one-time transaction. That kind of quote-unquote pettiness, fine. But in a person that I expect to have a 30, 40-year relationship with, told me a lot about her negotiating style, and I just was not comfortable with that. And we've had others. I negotiated a radiologist contract for one of my hospital clients. There was clearly the attorney who was nitpicking through absolutely every aspect of the contract negotiation, and I could understand where he was coming from about 80% of the time, but at some point you're just like, oh my gosh. So we got through it, but it was an extremely petty thing. So I think it's important to understand what the other side is going to be like to deal with, because by definition, most of these are ongoing relationships for some period of time, maybe just one discrete service, helpful to know. And then, as I remind all my clients when we enter into these, we're all enthusiastic when we sign, but every relationship ends. It just does, whether it's through a death, a divorce, change of service, a bankruptcy, whatever, every relationship ends. And so when you draft the contract and negotiate the contract, it's very important to think through what is going to happen when this contract is over, whether it's amicable or not amicable. You need to really look at what issues are going to be coming up in the termination period of the contract. So what does the contract say about the end of the relationship? If it's for a patient care service, who is going to notify the patients of the end of the relationship? How is that going to happen? If I'm, for example, representing a physician who has an established practice and is going to work for another one, so I'll just pick on an ophthalmologist who's going to work for a larger practice, I want to have language in my contract that says if my client leaves for any reason, whether it's voluntary, involuntary, so long as she's continuing to practice, you're going to send the following letter to patients. Be very neutral. You know, I'll just pick on Dr. Doe is no longer associated with the blah, blah, blah practice and will now be reached at so-and-so. And it's a very neutral letter that hopefully does not hurt either party, but saves a lot of hassle down the road when that relationship ends. Maybe she's decided after 5 years with them she's not happy, or she wants to go out on her own and have her own practice or relocate to an area 20 miles away. Better to have that defined up front so there's no fighting about it down the road. Because we're working with healthcare providers, what's going to happen to medical records? The general form of law is that the medical records belong to the facility or the provider that created them, I think would be the best way, the practitioner that created them. But then the information then belongs to the patient. So I have seen many fights, literally in one case, a physical fight broke out where the police were called on one of my clients as to who owned that medical record. So best to try to define that up front. even if the practitioner leaves, let's say we've got a medical director who's going to work for the facility, and we understand the facility owns the medical records on the patients, but the practitioner, the medical director, for example, needs to be able to access the record in case there's a licensing complaint or a billing dispute, some kind of a third-party payer audit, or any kind of malpractice suit. So we want to have terms where the practitioner can access the medical record. Who's going to own it? One thing. Who has the right to access it for certain circumstances? Separate issue. Who has to complete the records and collect the bills? So let's say we've got my hypothetical ophthalmologist going to work for this group. She leaves after 2 years and decides that she wants to practice on her own. There's going to be a lag. So she leaves on December 31st, 2020, and there still will be bills coming in. Who owns the right to that? Who's got the obligation to collect on those? Who has, does she get the right to have any information? Let's say she gets a performance-based bonus. Does she have the right to audit that kind of record after she's left so that she knows she's getting her full and accurate payment for her bonus? So very important to think through what's going to happen. And because we'll talk in a few minutes about insurance coverage, but again, because we're talking about healthcare delivery systems, we need to talk about tail insurance. Will there be insurance coverage post-termination of the agreement? We'll talk about tail insurance and those kinds of issues more in a few minutes. But so think through very carefully when you're negotiating the contract, what do we want to have happen when the contract is over?
Part of the negotiation process is obviously about leverage of the parties. And to Sigrid's point, if you're in a negotiating position where you have very little leverage, it does not make sense. You should not be in a position where you're asking for every item be solely in your favor, because you're obviously never going to get it, and it just makes everybody upset, and it makes everything a lot longer and more contentious in the negotiation. Because if you come out of the gate with that position, the other side's going to say, obviously we're not doing any of this, like, what is this person doing? So you have to really evaluate your position carefully, and obviously the smaller the amount of leverage, the more concise you have to be in systematic in choosing what is important to you and how far you can push the other side.
So I look for deal breaker issues and easy gives. Do similar kind of approach. I think, obviously you want to know what you're going to get paid, and if you think you're worth $200,000 and they're offering to pay you 10, that's a deal breaker issue, and we walk away from those. But then maybe they're providing some other benefit that's an easy give for them. They add you to their group health insurance plan, and you think, okay, that's a better give. I'll take 190 if I'm worth 200, but AIM is a great insurance package. So,
yeah, or if you would typically want more notice before termination or something like that, you would concede, okay, as long as I'm getting some sort of notice, that's probably okay, versus the most amount that you would feel comfortable with or covered by. So they're just gives and takes.
And then I always ask about any other documents that might affect the relationship. In the employment context, there could be an employment manual, billing guidelines, if it's for particularly when you're dealing with large institutional entities, insurance companies, or large healthcare systems, they may have billing guidelines. You definitely want to look for those before you get started to know whether there's anything in there. Are there any performance standards that would be set forth that you need to obviously read and review those? And I'll see references in my contracts to, they agree to abide by the, blah, blah, blah policy manual, the Cigna policy billing guidelines or something. Well, and then I ask my clients, have you looked at that? No, we didn't. We assume it's okay. Well, it's better look at it and see what it says. And some may be incorporated by reference, and others may be just kind of understood. So it's always, when you're negotiating a contract, it's always a good idea to ask about them. Is there anything out there I need to know?
So contracts are extraordinarily specific, even quote unquote forms by a party. Even if you hear the phrase that they're not negotiable, everything is negotiable, and everything's very party specific. So one slight change to one term is a totally different contract. So it's important to be very, very specific and detail-oriented. Even down to the precise legal name of the parties on the contract. Each person and corporation has a specific name, and you need to get it exactly right in order to make it enforceable.
I see a lot of trade names being used. Where it's not necessarily the legal name of the entity.
And perhaps it's a parent is the more appropriate. A parent corporation is more appropriate than a subsidiary. That also changes the terms of the agreement. A parent is more credit worthy, and that changes what we could be asking for instead of a subsidiary that might be judgment proof on purpose. So you have to be very cognizant.
And know who you're contracting with. Because we'll see, I deal with this pretty often where we'll have they're dealing with the local thing, but then they don't necessarily know that there's a big entity behind it.
Absolutely. You can also deal with that separately, in the event it's a type of contract where you would ask for a guarantee or something like that, then perhaps the parent comes in on that side in a limited circumstance, or vice versa, but that's another topic. So the dates in the contract are also, again, very specific. So, we have to structure it specifically to what the deal terms require. So many times there's just an effective date at the beginning of the contract, but we could be contracting about actions that will be performed in the future. And so if there's other commencement dates where certain actions need to be done, or outside dates by which an action needs to be completed, and if they're not completed, there are other consequences or remedies or termination dates. Those all need to be specifically laid out, and the defined terms need to be used correctly. Because otherwise, if it's confusing about what date by which you were supposed to do something, then it'll be difficult to enforce a remedy if everyone's unclear about what the date was supposed to be.
Then we look for representations that each party's made in the contract, and this is something I always check with my clients. We'll have something that says, we're incorporated in Delaware or something like that. Obviously, they need to make sure that those are abided by, because those fundamentally form the basis of the contract. I promise that I'm licensed in Maryland. If I'm not licensed in Maryland, the whole contract is probably going to be challengeable, not upheld by the court.
So by definition, a representation is a statement of fact. So we're asking in a representation section that folks specifically state that these items are true. And we're only entering into this contract because these items are true. And so while it might not be, sometimes representations are overlooked and not heavily negotiated, depends on the context. But you still need to read it carefully, because perhaps your lawyer doesn't know that this specific factual situation isn't true because of this, specific person that just joined the company made it untrue. And so that's where, again, attention to detail and your information that your attorney might not know could be very important to change the terms of the contract.
One of the important things I always look for in reviewing any contract is to look at the termination clause. I'm all about negativity here. I'm always talking about termination, but it is important to carefully evaluate the termination clause and how much language is in there, how much notice is required, what process needs to be done to terminate the agreement. They'll often have very specific notice requirements that should be followed in order to adhere to it. Notice has to be sent to here by a registered mail return receipt requested or whatever. You can't just use a phone call or an email to so-and-so. You have to follow the process. But also look carefully at the amount of time that's required. I've had a surprising number of clients that will say, I've got a 5-year contract. And then I look at it and it's got a 90-day termination clause in it, which is quite typical. And I say, no, you have a 90-day contract. And my clients, I find, don't look at it that way. That's often a surprise. I had quite a go-around with a physician client 6 months ago who felt that he was locked into a 5-year contract. And I said, actually has a 30-day termination clause. It's a 30-day contract. And he had not looked at it that way. And I think that's an important thing to remember for both sides of the agreement. Because when you're looking at it, you can always, if you don't like the language of the contract anymore, it's not working for you, you're getting paid below what your costs are, or you don't like to perform that kind of service anymore, whatever it is, look for the termination clause. It can also be a way, which is good and bad, for leverage if you want to, for example, raise your compensation. You're charging $100 an hour and you're now worth $150. You're not stuck with a 5-year contract. You're stuck with a period of the termination clause. And you say, I'm terminating it. We have raised our rates. I put a reason in there if I think there's some shot of preserving the relationship and I'm not in a snippy mood. I would say we're terminating it because the rates are too low. And so we have found it necessary and pursuant to provision 5.1, we're terminating the agreement. And if they love you, they'll pick up the phone and say why. And you say, well, we were charging 100 and we're now worth 150. And they might come back with a counteroffer. But terminating is always an option when it gets to that point. So, and sometimes we don't want to give a reason, and it typically doesn't require it. We had another situation, one of my hospital clients, that we wanted to terminate the relationship because we thought we were getting poor quality service and we didn't want to get into a fight about it. So we just said, pursuant to paragraph whatever, we're terminating the agreement. And I waited to hear if the other side was going to come back and say why, and they never did. So yay. And look carefully at the, restarting.
Oh, I was just going to say, and again, specificity is key here, because in other types of contracts that I work on a lot, it's very rare to have a no-cause termination clause. There's only by very specific reasons can you terminate the contract. And so, if you're, for example, in a lease agreement, if you aren't bringing in revenue up to a certain point over a 3-year period that's tested, and you've sent the documents to your landlord and they've agreed, that there's a whole process that has to be followed before you would even qualify to invoke your termination right. So, if financial viability is very important and you're not sure that it's going to work out for you, then you have to make sure that your termination clause is flexible in a way that allows you to get out if you need to. Because many times it's all very specific to whether it's a cause or no cause termination right.
And sometimes it's easier to invoke the no-cause termination rate if you feel there's cause, because you don't want to get into a fight about it, or it's not something that they can easily remedy. So so sometimes we counsel our clients about that as well, that maybe the no-cause termination is 90 days, but it saves a lot of arguing over whether they've adequately cured something that we think they can't cure, to use the 30-day for-cause termination clause. Right. So sometimes can be a judgment call. Look carefully at the scope of work of the job description, and consistent with what Caitlin was saying before, is everything you want in there. Sometimes we'll see, I negotiate a fair number where they're like, well, we'll expect you to do so-and-so, but it's not actually in the contract. So if it's not in there, it doesn't count. And then think about, do you have any special issues to address? If there's some performance requirement that we can't make, or there's let's say it says we're going to deliver the product within 3 days, no matter what. And I would say, well, what if it's a snowstorm on Christmas Eve? Are you going to make it, 3 days? Oh no, well then we would expect that they would waive that. So then we need to put some language in, unless extenuating circumstances apply, or there's a weather problem or something like that. And I'm always very cautious when I think about 72-hour notice provisions about whether that's going to fall on the Friday afternoon or 3-day weekend. So I try to leave a little flexibility for some of those kinds of things. And then look carefully at covenants not to compete. This is always an area of high litigation for attempts to enforce them or to waive them. Legally, a covenant not to compete means that you won't take your information and go down the road and use it to compete with the person that caused you to have that information in the first place, whether it's training, whether it's a customer product list. And so the notion is that you can't take all this great information and training that you've had and then just truck down the road and use it to harm the person who gave it to you. So the concept is good, but the courts have said consistently that they can only be used to protect the employer's interests. So sometimes they're overbroad. I one time saw a covenant not to compete that said that when, I can't remember if it was, let's say it was a physician contract, I can't remember, but the physician could not work anywhere in the United States after he left. Well, sorry, that is not going to be enforceable by the courts. It might be nice for the employer to be able to ensure that that person cannot earn a living, but the courts have generally restricted that, and they say the person has to be able to earn a living, and so they need to be drafted relatively narrowly. Anything that's longer than 2 years is probably going to be struck down by a court. Anything that is outside the service area provided by the contracting entity that is trying to assert the covenant not to compete is probably not going to be enforceable. If you're only operating in the Mid-Atlantic, you cannot prevent that physician from working in New York State, for example. So it needs to be tailored to protect the interests of the party that's trying to assert it. And then, like any other contract provision, as we talked about before, if you want out of it, see whether there's a legal way to do it. Never sign it assuming that you're not going to have to comply with it. But if you want out, there are sometimes ways to buy your way out or to negotiate your way out. Or in one of my cases, I represented a pediatrician who had been working at a practice. Pediatricians general practice pediatricians are relatively common, and her employer wanted her not to be able to practice anywhere in the county, which was quite a large county. And we said, no, they're not going to be harmed. People only travel so far to go to a pediatrician. There's lots of them around. The employer had not provided specialized training. She'd come with a fully board-certified pediatric training program. And so, yes, she couldn't take her patient list, but to say that she couldn't practice 20 miles away was something that I thought we would be able to defend in court. So it is a clause that sometimes can be negotiated out. And when I pointed out to the employer that we were willing to go to litigation on that, they decided, oh, never mind. They didn't want to litigate over something that there was a decent chance that they were going to lose. She has a right to earn a living. And sometimes I see them drafted so that the covenant not to compete does not apply if the employee is terminated due to economic circumstances. So the group practice is going out of business, and then she can open up shop down the road because there's nothing to be harmed by her competing. So they're not black and white. They can be individually tailored, and you have to think very hard about the interests of the parties when you're negotiating those kinds of things. And for my physician clients, they can be deal breakers. They can, they think about the fact that I'm married to another person who has the kind of job we can only have in this area because I'm working for some industry that's only in this area, and my husband wants to be able to practice down the road. So you have to think as a provider who might sign them, how important is that? Is this something I can live with? Again, every relationship ends. Think about what's going to happen down the road.
Another important section of many contracts is future decisions or future requirements of the parties. So a covenant, the definition of a covenant, distinct from the definition of a representation, is a covenant is a promise of future action. So perhaps you're going to covenant that you will continue to maintain your license and do every action that is required by the state in which it applies in order to do so, that you'll continue to run your business in an effective way. Sometimes they're a little bit vague, but they are promises between the parties about what is expected about their future actions. However, agreements to agree are a dangerous practice to enter into because they're not enforceable. So if you know that you want the other party to do something, you have to be specific about that and have a deadline or a termination date or something like that. You can't just say, we're going to agree to decide on that at a future time, because that won't be enforceable.
I see negotiation of future compensation in that often. Mm-hmm. The parties will negotiate in the future after the first year for what the compensation is going to be. Not legally enforceable, right?
Mm-hmm. Or we'll promise that, we'll talk about that when the time comes. Mm-hmm. For different items. Like, well, that's not worth the ink that it's written on, or whatever that saying is. But because, what happens if you don't do that, or the relationship breaks down in a way that you can't predict 10 years down the line, and they're not going to just come to the table and talk to you as you thought they would. You're more protected if you had a specific increase in your compensation laid out in the contract by a percentage, instead of just trusting, unfortunately, that the parties are going to continue to have a relationship that they have at the day that you sign the contract.
Another important thing, we talked about this a little bit earlier in broader terms, but is look at the insurance coverage for both parties. I'm a huge fan of insurance coverage because that protects the parties in the event that there's an issue down the road. So look for the types of coverage that would be available for the types of services that are being provided. Directors and officer insurance can protect the directors and officers of a corporation. There's premises liability insurance. There's general liability insurance. There's an umbrella insurance to go over the whole thing to protect for any gaps in coverage or excess judgments or whatever. So, and I actually, maybe you feel differently, Caitlin, I'm not an insurance expert, but I always tell people, call your broker who's incentivized to sell you stuff to see what kind of insurance coverage they would recommend that you have for your business, whatever your business is. If you're an individual physician who's the sole breadwinner, look at disability insurance coverage. You know, talk to an insurance broker about what they can do to protect you, and then you can have a conversation about how likely are the risks. I always find, not surprisingly, that the more likely the event is to occur, the more expensive the insurance coverage is. So it is very valuable to talk to a broker about that and work through it.
Absolutely, a broker is the best source of information, especially for costs. You know, one other thing to think about when we're talking about insurance is we would expect that whatever's in the contract is the minimum amount of insurance that you're required to carry. And so sometimes for negotiating reasons, we would say, look, this is a minimum. We will probably have more, or we have the option to get more, but this is all we're going to agree to be required to carry. So it's not a default under the contract if it's too expensive for us to carry more insurance. Both insurance and indemnification are two ways to defray the risk in whatever contract that you're drafting. And so while insurance is a pot of money that you look for from an insurance company, indemnification comes from the entity or person that you're contracting with. So it's only worth as much as that entity is worth.
It's based on your insurer.
Absolutely. So they're connected concepts, but indemnification is often heavily negotiated because a lot of things can happen, and if an indemnification provision is overly broad, then you, as if you're the indemnifying party
that made the promise to reimburse the other person if something happened,
then you could be on the hook for way more than you anticipated, based on the facts and circumstances as they come down the line. So you have to be very aware of what could potentially invoke that indemnification clause. So it's very important to think about that carefully. But it's all in context. So if the contracting entity that's providing the indemnity is a specific purpose entity that is only, has limited assets based on the structure of the organization, then, perhaps you would feel more comfortable giving indemnities because it's only worth as much as that limited entity is worth. So
one pitfall that I see in indemnification clauses, and feel free to add thoughts that you might have, but you don't have insurance coverage for the indemnification provisions that you grant. So if I agree to indemnify Caitlin for the services she's providing, and then Caitlin gets injured or sues me because of something I've done wrong, an insurance company says, oh no, we agreed to insure you, Sigrid. We didn't agree to insure Caitlin. Whatever promises you made to her are her problem. And insurance companies regularly deny coverage on those kinds of, they're really uninsured parties. And they'll say, well, we agreed to indemnify you. We're your insurance company. We agreed to cover you for your losses. If you have a car accident and cause damages, we agreed to cover you because we know who you are and we've got your driving history and all that kind of stuff. But we didn't agree to cover all the promises that you might have made to somebody else, the passengers in your car. Don't worry, if something happens, I'll take care of you. They're not necessarily going to agree to cover that. That's maybe not the best example, but it comes up a lot in businesses. I see frequently there will be parties that will offer mutual indemnification. They think that makes it better, which it doesn't. So I'll see let's say a physician employing or contracting with a hospital, and they have a mutual indemnification clause. The physician commits malpractice, that the hospital will be able to look to him for coverage. Well, no, because the individual's coverage didn't agree to cover the hospital. He's going to go bankrupt. He doesn't have the kind of assets that he might need to provide that kind of indemnification. So the parties need to think a lot about indemnification. It's not just a boilerplate legalism. It really is an important provision. And in that regard, we skipped over a little bit my pet talk on claims-made coverage versus occurrence coverage. So occurrence coverage is coverage that covers you no matter when the claim comes in. So it's based on the occurrence of the action. So if I'm a physician or let's say I'm a CCRC and somebody trips and falls in my property on the middle of 2019, and then I change carriers in 2020, and they get sued, a year later for something that happened, the trip and fall that happened a year ago on my property, the new carrier might very well say, well, sorry, I only cover you for mistakes or problems that happened in 2020. So when you terminated your insurance coverage in 2019, you need to have thought about what's going to happen to future claims coming down the road. So in the old days, all insurance coverage was occurrence-based. It was focused on the date of the occurrence and would cover you no matter when the occurrence was. With the fretting about the rising insurance rates in the maybe 70s and 80s or so, I may be a little wrong on the dates, but they began to focus on how can we bring the cost of the premiums down. So the insurance companies came up with the bright idea of then reducing the cost of the premiums at the time by only focusing on when the claim came in. So the 2020 carrier is going to say, sorry, the claim came in 2020, we're not covering you. And the 2019 carrier says, well, yeah, but you didn't get sued in 2019, so we're not covering you. So you have to look, and again, this is where a broker can be very helpful, but you have to look at whether you've got some kind of a post-occurrence coverage, and so that's typically called tail coverage. So claims made plus a tail equals occurrence coverage. This little equation that I came up with, but it helps me remember what the two types are, because the claims made just focus on the claim, and so then you need some kind of a thing to cover that kind of a gap. And so then we talk a little bit about Stark and anti-kickback issues, because we're talking about healthcare providers. So as we all know, we are not allowed to pay for referrals of Medicare or Medicaid patients or any other federally insured patients, TRICARE, anything like that. State law has, so that's federal, it's criminal. It has very serious consequences. In addition to going to jail, you would not get paid. So I don't know which is worse, depending on who you ask. But those can be very serious consequences. And so we look, when we're looking at these kinds of things, to see whether there's any kind of a payment for referrals. We'll talk about that more in a minute. But we're talking about bonus calculations and contracts. Those are the kinds of issues that come up by being paid some excess amount for referring patients. And an area that we frequently run into surprises on are employees versus independent contractors. And my physician clients regularly send me contracts to review, and it's not clear when I start whether it's an employment or an independent contractor relationship. Providers don't necessarily think about those kinds of services, and I'm using providers broadly. The parties don't necessarily think about what's an employment versus what's an independent contractor relationship, but you're always one or the other. It's black or white from a legal perspective, and so you're either an independent contractor or an employee. We all know what employees look like. They get paid on W-2s. Their employer gets to tell them what to do. The IRS, which really cares about this issue, as do the state tax authorities, focus on what's an independent contractor versus an employer. They want any kind of gray areas to become employment relationships, because employers have to pay more taxes. They are more sure that they're going to collect the monies that are owed to them. So they look for control issues. What control does the potential employer have? So I always use the example of the McDonald's employee versus the painter. So the McDonald's employee is told what they need to wear to work, what time to come to work, how to make hamburgers, what they need to do during their shift. They have a shift, their employer, their boss tells them what to do, and they're kind of tightly controlled in terms of their services that they're providing. They're classic employees from a legal perspective. The painter is the classic independent contractor. I call Joe Painter and I say, hey, come paint my house green and I'll give you $5,000. And he says, okay. He sets the hours. He decides today it's going to be rainy. He's got another job to cover. He's not going to come out today. He comes out tomorrow to work on the house. He knows all the details of kind of paint. He might ask me a few things about whether I want this kind of paint or that kind of paint, or, for another $1,000, I'll put on a coat of primer. But it's a pretty open-ended. He's got the expertise that I don't have. He knows what kind of brushes he wants to use. He provides all his own stuff. He provides all his own insurance. Those are classic independent contractors. When you're entering into a relationship, it's more clear-cut when you've got two businesses or two corporations, because they were clearly going to be independent contractors to each other. But if you've got an individual working for the entity, it's a pretty good shot that they're going to be construed as employees by any tax authorities that look at it. And it's not just maybe we don't get caught or whatever. It has, there are various states, Virginia is one that I know, that is actually actively auditing entities to look for people who are truly employees but are being characterized as independent contractors. It's a big issue in the industry. There are various reasons to prefer the employment model. If you are on that side, obviously it comes with higher costs, but it is also provides some safety. You've got some workers' comp coverage if they get hurt on the job, and you've got some other kinds of protections there. So I did want to talk a little bit, because we're in the healthcare arena, about the anti-kickback and Stark laws. And again, as I said before, any payment for the referral of patients, whether it's to self or others, for the referral of the kinds of patients, is generally illegal. They have thought of every scheme you're ever going to come up with. The statute is very broad. It says any payment in money or in kind, overt or covert, directly or indirectly, for referrals is going to be illegal. And it is a funny process when I sometimes explain this to physicians. I'll say, because they'll want to get some kind of a bonus calculation that says, oh, I get $5 for every patient I bring into the practice. And I say, I don't look good in stripes. I'm not going to do this contract for you. They put lawyers in jail too, and who are party to these schemes. And it's both sides. It's offering and receiving, or offering to receive, agreeing to receive, or agreeing to pay any kind of these kinds of inducements. So I'll say, oh, you can't get $5 a patient, and then there's a pause on the other side, and then you say, well, what if I buy him a car, or what if? And I always wait for that what if thing, as they're trying to think through some way to get around this. They've thought of it all. It's a very active area of enforcement. I have clients in jail. This is not an abstract thing not to think about. It is a very active area. So if you're in the healthcare field, I always recommend that you be very careful. I see payment for referrals hiding behind every tree and bush in every deal that I do that involves healthcare providers, because it's often there. The feds, several circuit courts have found that if even one purpose of the payment is to induce referrals, it invokes the statute. So it's very broad, and it's a very active area of enforcement. And I actually had one physician client a few years ago who said she was going to come up with a scheme where there were going to be 5 or 6 doctors engaged in a scheme that I told her I thought was illegal. And she said, oh, no one will tell. Yeah, every criminal conspiracy, there's always somebody who flips first. And when my physician clients come in, typically physicians, but sometimes institutional clients will come in, and they'll say, oh, well, we got a letter from, the Office of the Inspector General. We got a letter from the State Medicaid Fraud Control Unit. Every state has one, pursuant to federal law. And we got a letter, and they just want to do an audit. And they said it's friendly. And I'm like, it's never friendly. They might say they're being friendly, but they're not. And they tell you that to get better compliance. And so they'll send you this letter. And then my next question is always, have you fired any billing staff lately? And the answer 90% of the time is, oh, that stupid girl. We let her go 6 months ago. She wasn't any good. She was an idiot, blah, 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 blah. And I'm like, well, that woman caused a problem for you because she probably reported your billing practices to the feds or to the state. So there's always somebody who's incentivized. And the other great source are ex-lovers and ex-wives and divorce proceedings. So they're always in tune for this. The agencies read newspapers and magazines like the rest of us, and they're looking for court cases, things that come up that will cause this area to be identified as an area of enforcement. So problem areas that we run into in contracts, I tried to come up with a list of things that I see. Poor calculation of leave time, so in employment context. Examine holidays, leave, vacation, sick days, how are they calculated? Do they accumulate? What carries over? What doesn't? What do you credit for? What survives termination of the relationship? Those kinds of issues come up frequently, so I see those. Disability insurance, which we talked about a little bit ago. If there's I think a 1 in 3 chance, the top statistic that one hears, 1 in 3 chance of being disabled at some point in one's lifetime. It might be temporary. I broke my ankle and I fortunately have the kind of job where I can work from home. But if I didn't have that kind of a job, if I was a bricklayer, I have a friend who broke his ankle and he was out of work for 6 weeks. So a period of disability and employment is pretty common. So consider those kinds of coverage. For billing involving medical records, which many of our clients have, make extra care to make sure that they're accurate in compliance with current coding and documentation requirements. A lot of my clients come in and they'd last looked at the current codes maybe 5 or 10 years ago. Oh, guess what? They changed. And the feds expect you to stay current with those kinds of things. So it's important to stay current with all the issues. And then we talked a little bit about watching for variances that creep in over time. There'll be a contract that'll say, I'm going to pay you, once a month, or I'm going to pay at this rate. Or I had a client that had a big bonus calculation that he'd been working under for 5 years that was never memorialized in writing. And the contract said he was going to get paid this way, and he was really getting paid that way. And then he came in and he said, well, they've always been paying me this way for the last 5 years. And I said, well, the contract says you're going to get paid this other way. And it says any changes are going to be in writing. Do you have any documentation, any emails, letters, anything that obviously a contract amendment would be best? But no, we just started to do it that way. And that's a problem because most contracts contain boilerplate language that says that the parties can insist on interpretation of the contract the way it was drafted.
Absolutely, and I see that a lot when, a new administrator comes on, as you mentioned, and so they might look at, an audit of the operations of the practice and say, this isn't how we're supposed to be doing things, like, let's get this in compliance, and then maybe detrimental to, not detrimental, but, against what the parties have quote unquote agreed to. Mm-hmm. Contract amendments always best. Mm-hmm.
And for the same reason, I find integration clauses to be a little bit of a trap for the unwary. Again, boilerplate, usually at the end of the contract, and it says that this contract contains the entire relationship between the parties. And if you don't think through that, that looks like just lawyer mumbo jumbo. But I find that it can be a trap for the unwary in that I am told, my clients will tell me, oh, they promised me so-and-so. Here's their marketing brochure, and they said that in the marketing brochure it says that they're going to do pharmacy deliveries every day. But it doesn't say that in the contract, but that's what their marketing brochure says. I have been known to incorporate the marketing brochure as addendum C to the contract to say, here's all the stuff that you promised you would do, and as an inducement to us signing it, you need to abide by that. I had one client who went to work for somebody, and he said, well, I know what the contract says because the lawyer made us put in there, but what we're really going to do is so-and-so. And that doesn't stand up in court. So as lawyers, we have to say, attorneys can really help with contract interpretation and negotiation. It's not just a plug for keeping us employed, but the fact that what looks like English may not be. My most frequent statement probably first year of law school was, but it looks like English. There are terms that have very precise legal meanings that you might think as a non-lawyer what it means, but to a lawyer has a very specific meaning. The word fraud. Fraud is to a lawyer that leaps off the page, and a non-lawyer might just use it as I'm mad at you, but fraud has a very specific meaning, and there's a slew of other contract terms that we can rattle on about for several more hours. So having an attorney can be very helpful for this kind of issue. We're talking about healthcare providers. Learn the basics of HIPAA. It's not there. It's a complex doc, and the pages of federal regulations on it. But the basic concept is: don't gossip, don't snoop through medical records, and take great care to prevent the theft of data, including through cybersecurity measures. This is an increasingly enforced area of the law, and there are increasing number of problems in it. And you're seeing some really big payouts by some institutions who should know better about how they're failing to adequately protect their HIPAA protected documents. So invest in cybersecurity measures. If you sign it, you own it. That's another area that I run into sometimes, is that if you sign it, that means you're vouching for the accuracy of it. And finally, as it pertains to physicians and all other types of healthcare providers, there's a really good primer that the feds have put out that I tell all my physician clients to read, and we've put a link to it here. It's kind of the physician roadmap as to the basics of the anti-kickback laws. So it's easy to read, it doesn't take very long, they've actually made it pretty interesting. And even though, like many people, I'm not always a fan of everything the government puts out, I find this a very helpful document. So here we are. I don't know if we have any contracts or questions, I should say.
And thank you, Sigrid and Caitlin. We're now going to begin answering the questions submitted during today's presentation. As a reminder, you can still submit questions to the questions pane in your attendee control panel. Our first question: what are the biggest issues that you have run into?
For me, they just can't find the contract. Oh, I think we've got it. So keep a copy of the contract. I probably 9 times out of 10, when people send me their contract, it's missing the addendums, the attachments that are referenced in the agreement. I hardly ever get one. The only client I think that ever sent me one was a lawyer herself, and actually attended put all the attachments on the back. I see a surprising number that are signed in draft form. It's still in red line, and they never signed a nice clean copy, or the parties did not actually sign it. They'll send me a draft, or here's what I think we agreed to. I never understand why that last closing thing never so consistently doesn't quite get finished.
Mm-hmm. Yeah, a lot of problems I see are a disconnect between the business side of things and the legal side of things. And so the business people typically want to move as quickly as possible, and they've got everything worked out beforehand, and all that other mumbo jumbo doesn't matter, and let's just get it going, get it signed. And that type of attitude sometimes puts a lot of pressure on the lawyers and the parties to just, quote, get it done. Our role is not to stop a deal or get in the way. It's just to make sure everyone is fairly represented. And so sometimes one of the biggest just practical issues is the balance between, timing constraints and the tide of the negotiation versus wrapping up each issue that should really be addressed. And so all that's a conversation with the client to say, these are the considerations in moving forward on this basis.
Yes, I had a contract one time. I was told to draft an employment agreement by a physician for an employee. And I wrote him what I consider to be the 10 or 12 most important questions. What's the employee's name? What are you going to pay him? How often are you going to pay him? Give me a job description. And the physician called me back and said, oh, this is too much work, never mind. So kind of hard to draft a contract without knowing what the elements should be.
Well, thank you.
We're done.
And we would like to thank both Sigrid and Caitlin, and thanks for everyone for attending today's webinar on Contracts 101. Again, you'll receive a follow-up email within 24 to 48 hours with a link to view a recording of today's webinar and a PDF of the slide presentation. And on behalf of Whiteford, Taylor, and Preston and Leading Edge Maryland, thanks for joining us today, and have a great rest of your day.
Thank you.